Record. All right. So, chapter 7, ownership of real estate. The last chapter we just covered was estates in land. It describes the amount and kind of interest that one has in real property and what the differences are with that. How you could use the property. We spoke about easements and licenses. In this chapter, we're going to be talking about ownership of real estate. When you have one or more people or businesses that own real estate, how exactly does that work? And then we're going to be talking about condominium ownership and timeshares and talk about architectural styles and things of that nature in this chapter. So, in this chapter, we're going to describe different forms of ownership and explain the differences between condos, co ops, and timeshares. So, we're going to start off with tenancy in severalty. Tenancy in severalty. You could do the highlights here on the first page, 119 of this chapter. Um, Tenancy in severalty comes from the root word, which is not several, but sever. When your interests are severed from all others, you're the only owner. So, tenancy in severalty is sole ownership by one person or entity. It is not ownership from several by several people, it's ownership by one. The root word is sever, like I have written here on the slide with that line through there, severalty. Your interests are severed from all others. It's sole ownership by one person or entity. An entity is an artificial person for taxation purposes, like a LLC or corporation. The owner is free to devise the property to anyone they like in a will, to heirs or devisees. And what happens if you die intestate and you have no heirs that step forward to claim your property? The
They go
property
back to the
reverts
Government
state.
escheat.
as cheats back to the state. That means it reverts to the state. They sell it at auction, hold it in a fund for a year, and if nobody claims it, they keep it and do with it what they like. All right. We already spoke about this and I showed this to you, but now we're finally getting to it here in chapter 7 on page 120. Remembering legal terminology. I want you to write OR in capital letters and put it in quotes, and EE above capital letters and put it in quotes above giving and receiving. OR above giving, EE above receiving. The root word, if it ends in OR, that's the person who's giving whatever the root word is. If it ends in EE, that's the one who's receiving whatever the root word or product is talking about. So, devise, you guys still need to know what the root word is. What is devise?
Divisor.
What is devise? Devise.
Oh,
To
to
give,
give.
to give in a will. Person named in a will is devisee.
Okay, so devise is to give, to leave
Giving
property to someone in a will,
in a will. Yeah.
right?
Yeah.
So the devisor is the one who's leaving you their property, and the devisee is the one who's receiving it. When we give ownership by selling it or giving the property away, we're granting our ownership to someone else. So the grantor is the seller, the owner of the property, and the grantee is the buyer, the one who's receiving it. Legacy is your personal property that you've amassed during your lifetime. So the legator is the one who's leaving that property to someone, and the legatee is the one who's receiving it. A lease is a document where an owner intentionally transfers some of their rights and possession of their property to a tenant for a limited period of time as defined in the lease. And the lease describes the rights and obligations of the parties as well. So the lessor is the one that gives the lease. That's the landlord. And the lessee is the one who receives it. That is the tenant. Mortgage has that little asterisk next to it because it means the opposite of what you think it does. Usually, when you ask somebody what a mortgage is, they say it's a loan. No, it's not. A mortgage is a promise to pay. Banks don't make promises, they make loans. So you promise the bank that if they lend you their money, you agree to pay them back according to the terms in the note. Uh, there are two parts of a mortgage: the mortgage itself, which is the promise to pay, and the note, which is the financing instrument that talks about all the terms of the finances and the repayment, etc. So the mortgage is a promise to pay. Banks don't make promises, they make loans. In exchange, the borrower promises the bank they'll pay you back, the lender back, according to the terms in the note. And if they fail to, they could foreclose on them, take the property, sell it at auction, and use the proceeds to pay off the debt. Okay. We use mortgages here in New Jersey, uh, and the deeds. The Some other states have deeds of trust. We don't have a deed of trust type of system where there's a trustee involved. That's a third party that, when you've paid off the loan, they add to the public record a release that you have paid off the loan. And If you don't pay off the loan or you stop making payments, uh, they they don't release the lien in the property in the public records, and they give a deed to the lender so that they can just have it, the property, back to sell. So it's it's a type of foreclosure that's done privately. It's no through a third party called a trustee that holds on to the deed. uh, I guess would give you a good visual. Technically, that's not what's happening, but in theory, that's what's happening. The person is the trustee; they are holding on to the ownership, and they don't hand it over to the buyer until they pay off the loan. If they don't pay off the loan, they give it back to the lender. So it doesn't go through a court system. New Jersey, we have a judicial foreclosure process, so it works a little different. So the mortgager is promising the lender that if I don't pay you back according to the terms in the note, you can foreclose on me, sell the property at auction, use the proceeds to pay off the debt. So the one that's making that promise is the borrower. The mortgagor is the borrower, right? And the mortgagee is the lender. Okay. So you could either remember that whole story to figure out who the mortgagor is, or you could just do the singing of it. I like that bit better. The mortgagor is the borrower. Makes it so much easier to remember. You don't even need to think. Or you
Or the
can,
two O's or the two E's, right?
or yep, or you could think about it and look at the mortgagor has two O's in it. The word borrower has two O's in it. The word mortgagee has two E's in it, and the word lender has two E's in it. Okay. And I don't need to go down this whole list here explaining it. You guys get the gist of words that end in OR versus words that end in EE. All right. So I just have another slide about that same thing, and I just talk about these ones that I just went over. And I give you the definition of a lease and a mortgage here. If you guys wanted to snap a picture of that, by all means. This is the explanation that I have verbally been telling you so far, but you have not seen yet. I actually wrote what a mortgage is here and what a lease is. So if you want to snap a picture of that, I'll give you a second to do it. Okay.
All set.
All right. All right. Look, even lenders these days misuse the term mortgage. Take a look at this Lending Tree commercial for a moment. You guys probably all seen this one.
Looking sharp, Len. Who's the lucky lady?
I'm going to the bank to discuss a mortgage.
See, you need a loan, you put on a suit, you go crawling to the bank. This is how I dress to get a mortgage.
See, there, even the lenders are misusing. A borrower doesn't get a mortgage. The borrower is the one that gives a mortgage because a mortgage is a promise to pay. But they know, most people in the public don't know this. When they hear the word mortgage, they think of a loan, a mortgage loan. So it would be more correct if he's terminology usage if they said, this is how I get a mortgage loan. But they just said, this is how I dress to get a mortgage. Okay.
I just go to Lending Tree. I calculate how much home I can afford. I get multiple offers to compare side by side. And the best part is, the banks come crawling to me.
Everything you need to get a better mortgage. Original Lending Tree. Banks you win.
Okay.
Awkward.
Awkward. It's a clever commercial.
Look.
All right, so let's talk about the forms of ownership here that we're going to go over. We only went over one so far, which was tenancy and severalty, which comes from the root word sever, where your interests are severed from all others. So it means sole ownership by one person or entity. We're going to go over tenancy by the entirety, which is an ownership by married couples who own the property entirely together. Tenancy in common, or a TIC for an abbreviation there. This is the default form of ownership when you have one or more owners that are not married. And then we're going to go over joint tenancy. In a joint tenancy, it has one benefit only, and that is something called the right of survivorship. So we're going to go over how to create joint tenancies. What are the four unities, the four things you need to have in common in order to have a joint tenancy. We're going to go over how to terminate joint tenancies and what is the only benefit of having a joint tenancy, which is the right of survivorship. And tenants by the entirety also have a right of survivorship, which is basically when one of the owners dies, the surviving owner or owners will automatically get the ownership. Okay, so real estate licensees, we're going to go over this and I'm going to teach you the ins and outs of it. But one thing be aware of, this, we would never give legal advice to someone as to what form of ownership they should take. But we do need to understand the different forms of ownership. So if you get a question on your exam that asks you, how would you advise that these buyers take ownership of this property? Even if there's a perfect answer there that you know would fit, select the option that says none of the above, because it's legal advice and we don't give legal advice. It's a trick question. Okay. We don't advise people on how to take ownership. Now, if the question says, what form of ownership would this be? That's a different question than how would you advise a buyer to take, which form of ownership to take this property as. That's different. That's legal advice. Okay.
But we can explain them.
Sure, but I wouldn't get into it because that's legal advice. Don't even get near the border of explaining things where it could be construed by somebody that you've given them legal advice because you've explained to them the differences. Okay. This is more for our own edification. Like if we go in for a listing and we see the deed and we see the type of ownership that's listed on the deed, we know how to interpret it better for ourselves. But when it comes to buyers, we won't get to the point that this should ever come up in a conversation with a buyer. Okay. They could talk to their attorney about this. So tenancy in common, or a TIC, in the commercial real estate world, commercial agents love their acronyms, and a TIC is the acronym for a tenancy in common for short. Most residential agents, you say a tick, they don't know what you're talking about. You know what a tick is? They'll be like, huh? It's a bug. You don't want that nasty thing in you. You have Lyme disease. No, that's not the kind of tick we're talking about. We're talking about tenants in common. Now, tenancy in common is the default form of ownership. You should write that there next to or under tenancy in common. Default form of ownership. When two or more people own property, they do so as tenants in common. Okay, so it is impossible to distinguish physically which specific half or third of a property is owned. Tenants in common do not necessarily have equal shares. In a tenancy in common, each owner can sell, convey, mortgage, or transfer their interest without the consent of the other co-owners. And upon the death of the tenant in common, that their interest passes on to their heirs or devisees in a will. Now, if a tenant in common wants to dissolve their co-ownership, but their partners do not voluntarily agree to buy them out or sell the property, you're not stuck owning the property with them. You could partition it. A partition is a court proceeding where you sue your co-owners, forcing them to divide the property if possible. And if it's not physically possible to divide it, the court will order the sale of the property, in which all the co-owners will split the proceeds according to their fractional ownership shares of interest. Now, because of that, it is a forced sale. So therefore, it's a form of involuntary alienation. So if you get a question on exam and it says, which one of these is a form of involuntary alienation? And they give you a bunch of different examples or different words or terms. Partition would be the one that you would select there if it was an option, because a partition is a court proceeding where you sue somebody, forcing them to sell or divide the property. So therefore, it is involuntary because they didn't want to, right? And in New Jersey, a conveyance of two or more persons not married to each other creates a tenancy in common, unless otherwise stated in the deed. The tenant's shares would be equal unless you specify otherwise in the deed. Okay. All right. So I'm just making notes for myself to make up all kinds of different AI images to fancy up this slideshow to have comparisons of things a little bit better. Just getting ideas as I'm teaching this, and I'm getting a hang of the AI crap. So I'll be spending a lot of time doing that. All right. So you guys have all these highlights down on page 120 and 121. Let me know when you do. Yes, I drink a lot of liquids teaching this class. Mouth tends to get dry if it's always running. Oopsie. Not good to spill water on the book. Everybody good? All right. So here are the details of tenancy in common. You may want to snap a slide, a pic of this. So tenancy in common, known as a TIC in the commercial world, is the default form of ownership when there's two or more owners, whether they're people or entities like LLCs or other business entities that are not married to each other. This would automatically create a tenancy in common unless otherwise specified in the deed that you wish to take ownership in another form. Two or more owners, the default form of ownership is tenancy in common. You would have to specify you wish to take ownership in another form. Otherwise, this is the default form of ownership. If you're married, it would be a tenancy by the entirety. Otherwise, you could specify you wish to create a joint tenancy, but we'll get into that one later. If you don't specify it, your tenants in common. Now, a corporation can be a partner with a partial ownership interest in a property as a tenant in common. Owners can have unequal ownership shares of interest in the property. You could have one owner that's 25% owner and the other has 75% ownership. But if you don't specify that in the deed, the default is 50-50. It's equal ownership shares amongst the owners. So if you put up 75% of the cash and your friend put up 25%, if you don't specify that you're 75% owner of the property, you're 50-50, no matter how much money you put up. So important detail to discuss with your attorneys, because we don't decide what way to take ownership. Now, owners can sell their interest without the consent or permission of the other co-owner or owners. If this happens and you have somebody come to you and say, yes, I'm looking to sell my property, and you find out that there's other co-owners, ask them, do they want to sell their interest in this property too, or are you only selling your partial ownership interest, or is the entire property being sold? It's important to understand, because if only one person is selling their interest in a property that they co-own with others, use extreme caution, because in most circumstances, this could be categorized as a security. And unless you have a special license to deal in securities, as well as the license, the real estate license, you're going to be violating some laws. So you either have to have both licenses, a license to sell, deal in securities, and the real estate license, or you could partner up with somebody who has a license to sell securities.
So just to just to know exactly what you're saying. So you're saying if I want to sell a property that two people own, I have to have this type of special license. Otherwise, don't do it.
No, if two or more people own a property together,
Two or
but only,
more.
yes, two or more people own a
Okay.
property together, and only one of them is looking to sell their partial ownership interest in that property, in that partnership. The others aren't
Okay.
selling. The others aren't selling. They don't want to sell.
Oh, the others are not selling.
Yeah, you only want to sell your interest in that property. You could do
Mhm.
that. You could do that. There's nothing wrong with that. But if somebody comes to us as licensed real estate agents to try to sell only a partial ownership share in a property, this more often than not is classified as a security. So we need to, in addition to our real estate license, we need to have somebody who has a license to sell securities, because in security, when you sell securities, you have to register the security with the FTC, the Federal Trade Commission, and the state of New Jersey. You have to have a special licensing to deal in securities. You have to prepare a prospectus for any potential buyers of this partial ownership share, which is classified as a security. Notifying a prospectus is basically informing people not what the upside is of buying this property or this interest in the investment in this property, but also what are the possible risks involved when purchasing this property or which is an investment, right? So that's what the person with that special securities license is licensed to do and prepare. And we don't have that knowledge because we didn't go to school to learn about securities and dealing in securities, right? So licensees must use caution when selling only a partial interest from one owner. It could be classified as a security, and you would need a special license to deal in securities, along with real estate license when selling partial ownership interest in a property. I had a commercial real estate agent once sent me he was one of my students. He got his broker's license through me, and he sent me an interesting article because he was in commercial real estate, and it was about this very topic. It was about 4.5 pages long. All right. And I must have read it 10 times, and I was still racking my brain trying to figure out when exactly would it not be considered a security in the eyes of the IRS. So this is something the IRS gets involved in, and I couldn't figure it out. So I really don't deal in partial ownership interest unless there's somebody involved that has the license to sell securities. All right, so owners have an undivided interest in the entire property, meaning you cannot physically distinguish which part of the property is yours and which is mine. If we're 50-50 owners in a property, you have 50% ownership of the entire property. It's not like we drew a line through the property and this side is mine and that side is yours. Does that make sense? Okay. So you cannot physically, so that's what they mean by we have an undivided interest in the property.
This security thing is important for exams, or this is just for the
No.
information? No.
That's important to keep you out of jail.
That
Okay. No, you're not going to get anything on that on exams about it being classified as a security. I'm just
so
sharing
that
this
yellow thing
information.
is just for the information, yellow lines.
Correct. Correct.
Thanks.
Correct. So all owners will have an interest in the entire property. Okay, so unless you buy out your partner's interest, they'll never own in severalty, because if you die, you can leave it to your heirs or somebody in a will, right? When a co-owner wants to sell and the others don't, what are your options? You could ask them to buy you out, or you could sell your own interest, but that may be difficult. And if you go to a real estate agent to do it, you need special licenses for that to deal in the securities, right? The owner can sell their own interest and seek out their own buyer for their partial ownership shares, though. But when we do it, you need special licensing for that. Or you can partition the property as a property owner. And that's basically suing your co-owners, forcing them to either physically divide the property, if possible, which it may not be, or to sell it. And then the proceeds are split according to your ownership shares. Okay. So a partition is a court proceeding where one co-owner sues the others, forcing them to divide the property if physically possible or sell it. This is a form of involuntary alienation because it's done by force. They don't want. That's what involuntary is, right? And alienation is a transfer of property. So this is involuntary alienation. All right. So there's my explanation, my full explanation of everything you need to know about a tenancy in common. Can you leave your shares by will to your heirs? Yes. Okay. Can you have unequal ownership shares of interest? Yes.
Oh,
Yes. You could have a 25% ownership and your partner have 75%. It doesn't
Yeah.
need to be equal ownership shares.
Okay.
Now, in the next one, we're going to go over the joint tenancy. Is it joint tenancy? Yes. In the joint tenancy, you cannot leave your shares by will to heirs, and you must all co-owners must have equal ownership shares of interest. Okay, so that's wherein the difference lies. But what is the only benefit of joint tenancy? Well, I call it the poor man's will of sorts. Because the only benefit of a joint tenancy is that anytime one of the co-owners dies, the surviving co-owner or owners will automatically equally split the shares of the owner who died. That's why they can't leave it in a will to their heirs. So let's write next to joint tenancy and put a little arrow here where it says two or more people, not entities, because a corporation can never own real estate as a joint tenant. A corporation can have partial ownership shares as a tenant in common, but not as a joint tenant. The reason being is joint tenants automatically equally split the shares of the owners who die. Corporations don't die. They're artificial entities. All right. So they're fictitious people for taxation purposes, right? So a corporation will never die until it's formally dissolved. Corporations don't die, people do. Right? So this is why a corporation can never own as a joint tenant. So it's important to know for exams. Two or more people can choose to own property as joint tenants. The main feature of joint tenancy is that it carries with it the right of survivorship. So you need to know the terms right of survivorship. What does that mean? It means it means that if one of the owners dies, the surviving owner or owners will automatically equally get the shares of the owner who died. They'll split the shares equally. Okay.
So
remember,
it doesn't go out, it stays in.
Yeah, it doesn't. Your heirs cannot. Your heirs can. Your heirs can't claim ownership. You can't leave it in a will to somebody, because that's the whole purpose of a joint tenancy. Is that your co-owners that you bought the property with will automatically equally get the shares of the owner who died. Now, I guess you could try to think up scenarios of when this would try to make sense for people to take co-ownership of a property like this with each other. But ultimately, it's legal advice and you need to talk to an attorney. We do not give that legal advice when it makes sense to take ownership as a joint tenancy. Okay.
It's mainly for tax purposes because of the Class A beneficiaries.
Well, it could be a tax benefit because it doesn't need to go through probate. The survivors automatically equally split the shares of the owner who died. But maybe you're buying the real estate with some co-owners, and you don't want, if one of the owners dies, you don't want their kids like trying to force a sale, getting their shares of the ownership and forcing the sale of the property that is being used for a business purposes, for example. Maybe that's an approach, or maybe there's another way that you could do it that's better. I don't know. That's why you need legal advice. I don't give that advice, so I really couldn't tell you. But I'm just trying to think up a scenario for it. Well, when does it make sense to have a joint tenancy? Okay. So you guys got your notes and your highlights, or are you still doing that?
I'm good.
I'm good.
Okay. All right, so let's see what else. In order to create a joint tenancy, all the let me see. In order to create a joint tenancy, you must specify at the time you take ownership of the property that you want to create a joint tenancy. If you don't, then the default form of ownership with two or more owners is what?
Tenancy in common.
Tenancy in common. So you need to specify you wish to take ownership in this fashion. Otherwise, you're going to take ownership as a joint tenancy if you don't, tenancy in common if you don't. So the purpose of taking that joint tenancy is that you get the right of survivorship. That's the only benefit. And in order to create a joint tenancy, other than specifying you wish to create a joint tenancy, you have to have 4 unities in common. There's a little acronym here to remember those 4 unities. TTIP, the unity of time, title, interest, and possession. I know it's not in that order in the book. For some reason, they jumbled up the order in this book. Usually they have it in that order: time, title, interest, and possession. So let me explain. So in your book here on page 121, highlights under creating joint tenancies, right above it, 4 unities required to create a joint tenancy, TTIP, and highlight to create a joint tenancy in New Jersey, language in the deed must expressly state the titles to be taken in that form of ownership. Because if you don't, the default ownership is tenancy in common.
When you say units, are you speaking like
Unities. Unities
what?
are things you have in common.
Okay.
So
Not
the
real estate.
now here, let me explain. Let me elaborate. The 4 unities, TTIP, time, title, and interest possession. You have to have the unity of time. That means that all joint tenants must acquire their interest at the same time. The unity of title. All joint tenants must acquire their interest using the same deed that transfers that ownership interest. The unity of interests. All joint tenants hold an equal undivided ownership interest or equal ownership interest. So you have to have equal shares of ownership. You can't have one person that's 25% owner, another one that's 75%. They must have, if you ever see that, you know it's not a joint tenancy. Okay. If everybody doesn't have an equal ownership share, you know that it cannot possibly be a joint tenancy. Okay. And the unity of possession. This is the one where you can't physically see which part of the property is mine and which part is yours. If we're 50-50 owners, you're 50% owner of the entire property, not that side of it, and I get this side. Okay. You have a 50% of the possession of the property is undivided. So that's what we mean by the 4 unities, the 4 things in common that you need to have in order to have a joint tenancy. If any of these things don't apply, it's not a joint tenancy. You know, it's not a joint tenancy. Okay. So I wrote here a little definition for possession to fully explain that, because apparently that one does require explanation. The other ones are pretty obvious, like hold equal ownership interest, or you could say shares of interest, you know. Possession means you cannot physically distinguish which part of the property is owned by an individual. If you're a 50-50, if you're 50% owner, you own 50% of the entire property and cannot physically distinguish which part is yours versus the co-owners. Let's see if I could even further clarify. Where is that? Okay. Or shares of ownership. Example 50/50. Okay. Let me know when everybody's done writing their notes here. You need to write down 4 unities TTIP, time, title, interest, possession, and 4 unities required to create a joint tenancy, and do these highlights. Let me know when everybody's got it, so I can move on to the next slide. I'm going to further explain joint tenancy some more.
I don't
I
really
don't really
understand
understand
the
the
difference
difference.
between tenancy common and joint tenancy. Like, what's the main difference? Just the
Well,
4 T's?
there's first of all, the joint tenancy has the right of survivorship. Tenancy in common does not. You could leave your ownership interest to your heirs or devisees in a will. In a tenancy in common, you could have unequal ownership shares. In a joint tenancy, you cannot. In a tenancy in common, co-owners can get their ownership at different times using different deeds. In a joint tenancy, you cannot. You have to have those 4 unities in common.
But what's the point of a joint tenancy, I guess?
Talk to your attorney. Remember I said that's legal advice, and we don't give legal advice. So this is something that we just need to be able to identify when there is a joint tenancy and understand how
Okay.
joint tenancies work. But we don't need to know when when you would use it. I know you really want to know this knowledge, but that's legal advice, and we should never talk to anybody about this because we don't want in any way to ever be construed as us giving somebody legal advice. But I don't know. I really don't know because I never gave the advice on it. I really couldn't tell you. I understand joint tenancy, but I don't know when it makes sense. Gabriella said it could make sense for tax reasons. Yeah, because it doesn't go through probate, and therefore the transfer of ownership is automatic. On the death of one of the co-owners, the ownership shares automatically or equally split amongst the surviving co-owners. Doesn't go through probate. You don't got to pay taxes on getting that ownership interest, right?
Not only that, but it's also because I'm in the industry of financial industry, and we use the joint tenancy quite often. So
okay.
mainly is because he overpassed the will. So it doesn't matter what the will says, the joint tenancy overpass it. So
Yeah,
regardless if
because
you have errands or not, the joint tenancy, the owner will have the ownership of the property, regardless who are your errands or whatever it says on the will.
And the reason being is because one of the whole purposes of joint tenancy is you cannot leave your interest in a will, because the sole benefit of having joint tenancy is the right of survivorship. That on your death, as one of the co-owners' death, your co-owners will equally automatically split the shares of the owner who dies. So you can't leave it in a will to heirs. That could be an exam question all on its own, understanding that, that in a joint tenancy, you can't leave your shares in a will to somebody, but in a tenancy in common, you can. Let's see. Let's ask AI a question here, right? Why would anyone want to create a joint tenancy other than for tax benefits? It's not reading it to me. Okay, great. Let's see. Beyond the potential tax advantages, the primary reason people create joint tenancy is for the right of survivorship. Yeah, we know that, but which allows properties to bypass the often long and expensive probate process. While taxes are a common driver, joint tenancy offers several practical and legal benefits. Avoidance of probate being one. Some people call it a poor man's trust. I got there the poor man's will. Immediate access. Surviving owners gain immediate control and use the asset like a primary residence or bank account rather than having frozen for months while the estate is settled. Will overriding. The right of survivorship typically overrides any conflicting instructions of a deceased owner's will. Let's see. Equity and fairness. Joint tenancy requires equal ownership. 50-50 for two owners, which can foster the sense of shared responsibility. Ease of setup, creating a joint tenancy is often simple as correctly titling the deed or bank account, making it much less expensive than drafting a complex trust and will. Protection against creditors. After death, in some jurisdictions, the property may be protected from the individual creditors of a deceased owner once it passes to the survivors. That's a new one. Okay, that's interesting. For business partners, it can ensure a company continues to operate smoothly without disruption if one partner passes away. Like I gave the example, so the kids aren't saying they want their interest so they could sell the property and get their money, and force the sale, and then the business gets shut down because you no longer have a property to operate it in. Or relationship stability. For married or committed couples, it ensures the surviving partner can remain in the home without legal challenges. Well, it's not joint tenancy, it's the right of survivorship they're explaining there. Because the tenancy by the entirety is for married couples, and they also get the right of survivorship. Oh my God, this thing goes on and on. Okay, I'm not going to sit here. Wait, it's got a little more. Holding assets as joint tenants or tenants by the entirety is not an alternate to establishing a living trust. If your only concern is making sure your spouse is able to inherit the asset without issue, joint tenancy may work. Property is often held in joint tenancy ownership, especially by married couples, because it's easy to set up, or you could just set it up as a tenancy by the entirety. It's same benefits. And it's immediate. Because it's easy to set up, convenient, avoids probate and the difficulties of passing title to property at death of one of the tenants. If you're weighing against this other options, okay, that's it. So there you go. There's the benefits of or other possibilities of joint tenancy. It's not many, but there's a couple. All right. Everybody got these notes? Because I'm going to show you how you can break down a joint tenancy and still have some joint tenants and some that aren't. Because in a joint tenancy, just like with a tenancy in common, if you're alive still, one of the partners can sell their ownership interests without the permission of their co-partner, their co-owners. But what does that do to the joint tenancy? Breaks it up a bit. So here is all my instructions about a joint tenancy that I call the poor man's will. You have to have two or more owners, usually not married to each other. A corporation can never be a joint tenant because of its perpetual existence. A corporation will never die unless it's formally dissolved. To create joint tenancy, it must be specified in the deed that ownership is to be taken in that form at the time you purchase the property. Otherwise, the default form of ownership for two or more people not married to each other creates a tenancy in common. The only benefit to having joint tenancy is the right of survivorship, which means if one co-owner dies, the surviving co-owner or owners will automatically equally split the shares of the owner who died. So owners can't leave or devise their ownership shares by a will. All owners must have equal ownership shares. Example, 50-50 ownership. You can't have one that's 75% and one that's 25% like you can with tenancy in common. All owners hold an undivided interest in the entire property and cannot physically distinguish which part of the property belongs to who. Each owner can sell their interest without the consent of the other co-owners. This, however, will destroy the joint tenancy, converting the new owner's interest to a tenancy in common. So if there's 3 or more owners, the original owners will all remain as joint tenants, but the new owner will be a tenant in common. So it's a mixed form of ownership amongst the owners. Owners can partition the property. So if you want to sell and the other co-owners don't, you could take them to court to force them to. And it is possible to be converted to a tenancy in common or tenancy in severalty. I'll show you how now. So if you want, snap a picture of this slide, and then I'm going to change the slide. 3.
So for siblings, joint tenancy is okay. I mean, if there are 3 brothers, they can
Yeah,
divide
sure.
3 equal parts.
Sure, they can.
And if one dies, they both can distribute equally.
It'll automatically get split their shares to the other ones, the other joint tenants. Okay, but they can't leave it by will. So if any of them have kids of their own, they can't leave it to them. Okay. All right. So the video explaining joint tenancy. Well, we're making it right now. So here is a joint tenancy. Okay. Joint tenants require 4 unities in common, TTIP, and must specify they wish to take ownership in this form when they buy the property together. Otherwise, the default form of ownership is tenancy in common. So here in this picture, you have 3 owners, A, B, and C, all have equal ownership shares. What form of ownership is this?
Joint
Trick
tenancy.
question. I didn't give you enough information. You didn't ask any questions. I just told you you got 3 owners that have equal ownership shares. That could be a tenant in common too.
Oh, yeah, that's true.
Remember, to create a joint tenancy, you have to specify you wish to take ownership. So you should have asked me more questions, but that's a bit of a trick question because we're talking about joint tenancy right now. So obviously your mind is on joint tenancy. So, but this is a question you have to ask. You need to probe a little bit more because I didn't give you enough information to decide if it's tenancy in common or joint tenancy. Okay, so let's just pretend that all 3 of them are joint tenants. Okay. What happens if owner B dies?
Then his shares will be automatically distributed to the other owners equally.
So there you go. Owner B dies, the shares are automatically split between A and C, the 2 remaining owners. Okay. Yes. And what happens if owner C dies?
Then everything goes to owner A.
And then how do they own the property?
By right of survivorship.
That's how they get the ownership shares, but how do they own the property if there's one owner?
Now there are what's that word? Severalty.
They own it in severalty. So there you go. So now if C dies, then A will own it in severalty. And now they could leave it in a will to their heirs if they wish.
Yes. So that's like a waiting game, Lord Jesus.
Well, you would have to create this joint tenancy for a specific reason that you wanted that joint tenancy.
But I know a family that has that. They have a house. It's a 4-family house. Mm-hmm. And they all the daughters and the mother, they all went in and they bought it together. And so that's how it's set up. They have shares.
So they created a the joint tenancy, or they had a life estate?
A joint tenancy.
See, we got different kinds of things too. Remember, there's a life estate that you could have too, but that's not a life estate is also a form of ownership for as long as you're alive.
This is a
But
joint tenancy because
yeah.
I grew up with the family, so and I
Okay,
hear
so
the
you know.
discussion. So
Okay.
as the ones are that own it are dying, the
Yeah.
other ones are getting their shares. Yeah.
Okay. And the thing is, though, if they're still alive, they could still sell their interest without the permission of the others. But what if they do that? In this example, we have owners A, B, and C. Nobody died. But C is sick and tired of A and B's crap, and he sells his ownership shares to D. What did that do to the joint tenancy? Well, D did not
Tenants
get
in
their
common.
ownership at the same time or by the same title, so they're a tenant in common with A and B. However, A and B remain as joint tenants with each other, so they still have the right of survivorship. So now if B dies, there's only A and D left as tenants in common, and there's no more joint tenancy. Either one of them now can leave their shares in a will to heirs. And I have that whole explanation I just gave you. I got that all typed up here at the top of the screen. That's why I'm not reading it to you, because that's why.
So for both of them, will it be tenancy in severalty individually or no?
No,
If
because
only one,
there's two owners of a property now. Severalty is one owner, sole ownership. There are two owners, so it's tenants in
but
common.
he was joint tenant and he was tenancy in common. They were
Yes,
in different,
but yeah, because there's more than one owner on the property, it can never be tenancy in severalty. Not
got
unless
it.
you buy out the other person or they specifically wrote in their will that they're leaving it to you. Okay. All right. And tenancy by the entirety also has the right of survivorship. This is ownership between married couples. Over here, we write tenancy by the entirety, special tenancy between spouses. The older versions of this book said tenancy by the entirety is a special tenancy between husband and wife. Now they write between spouses or married couples because gay marriage is now legal in New Jersey. So now gay people get to experience the same miseries that the rest of us do. It's a joke. It's a joke. Yes. Laugh. It's a joke. I'm not meaning to offend anybody or the institution of marriage. It's a joke. Okay. All right. So the owners must be married. They must be spouses when they receive the property. The owners have the right of survivorship, just like joint tenants. So when your spouse dies, you automatically get the ownership. There's no right to partition. Yeah, imagine that. You want to move, so you sue your spouse, taking them to court. So you're forcing them to sell the property so that you could move somewhere. You guys got other issues you need to work out, right? If you want to partition with your spouse. Now, in New Jersey, a conveyance to a couple who are legally married to each other or registered domestic partners or members of a civil union creates a tenancy by the entirety unless the deed expressly states otherwise. In New Jersey, couples 62 years of age or older can register for domestic partnership if they meet certain requirements. When a couple gets divorced, the tenancy by the entirety is broken and they become tenants in common. New Jersey does not recognize common law marriage. Under New Jersey law, a couple in a civil union are entitled to the same rights as a married couple. Okay. So basically, that's when people just live together for a long enough time and they like to be recognized as a couple. Well, that could also be common law marriage. If you live with somebody and are together for a long enough period of time and you're recognized by most people as a couple, you can be considered married in some states that have common law marriage without actually going through the marriage process. That's what common law marriage is. Common law marriage is not that you live together for a long enough period of time and you're automatically married. You have to be viewed by others as a couple and want to be married, but you just don't go through the process. This is known as
This is
common law.
this is applicable for New Jersey as well?
No, New Jersey does not recognize common law marriages at all. And imagine how that would form now that we have gay marriage together. You live with your buddy long enough, you're married now, because you'd have to be recognized by others as a couple and want to be considered married. That's the technicality on it. That was the joke that we always used to say, yeah, you live with your buddy long enough period of time, boom, you're automatically married. No, that's not the way it works. So let's take a look. I actually have I got a breakdown here with that. Ownership by married couples, primary marital residence if married after May 28, 1980, or to all properties if married before with those dower and courtesy rights, would you have that right of survivorship? Now, New Jersey does not have common law marriage. Okay, I got a link here. Let's click on it, and I could show you a little information about common law marriages. Now, here's some states that have common law marriage. Here's the breakdown of the states that recognize common law marriage that may necessarily not have it themselves. Look, and they may have it for certain reasons, like for inheritance purposes only. If relationship began prior to 1196, if created before 1197 in this state, Georgia. Let's see. Okay, these are all 50 states' rules on those that recognize common law marriage. Do they recognize it fully or only for certain purposes? For inheritance purposes.
How many years determines it? Is it 7 years?
It depends on the state that you're in.
Okay.
Okay. Like if we scroll long enough, okay, now we see all the states that do not have common law marriage or recognize it. Let me see. States previously allowing common law marriage. Oh, they used to give a better breakdown. Okay, states with common law marriage and states previously allowing common law marriage, where they no longer have it, but they previously did. Alabama got rid of it in 2017. Florida got rid of it in 1968. Georgia in 1997. Indiana in 1958. Ohio in 1991. Pennsylvania just got rid of it in 2005. And South Carolina just got rid of it in 2019. And these are all the states that recognize common law marriage. Okay. And these are all the, let's see, the states with common law marriage and why. So some have just common law marriage just for the sake of being common law marriage. Others have it only for specific reasons and with specific conditions. But we don't need to worry about it. We don't have it here. So there you go. So when a couple divorces, ownership reverts to tenancy in common. So now you can partition the property and sue your ex-spouse, forcing them to sell the property or buy you out. This is what often happens when people get divorced, right? They argue about the property. Not necessarily that one gets awarded the property. They can be forced to sell it, and then the proceeds split amongst them, divided equitably. Now, that changes a bit when you got kids and such. You could also try to protect yourself with a prenuptial agreement. These are all kinds of legal protections you could have in place. Make sure that they're written up by an expert. Don't do AI prenuptial agreements, because prenuptial agreements are can be easily broken through with a good attorney. They follow the money. That's how. No right of partition while you're married, only after divorce. A corporation cannot be a tenant by the entirety because corporations don't get married. People do. And so they do have the right of survivorship, and they do have the right to partition only after divorce. Okay. All right, so in a review, tenancy and severalty is ownership by one person or entity. Tenancy by the entirety is ownership by married couples that do have the right of survivorship. Tenancy in common is the default form of ownership when you have two or more people or entities that have partial ownership of a co-owned property. But they could leave their properties in a will to heirs. They could have unequal ownership shares. They could leave their shares of interest in a will to others. Joint tenants can't do any of that because the benefit is the right of survivorship, but they have to have four unities in common to create that joint tenancy. The unity of time, they got their ownership at the same time. The unity of title, they got their ownership using the same deed to convey that ownership interest. They got the unity of interest, the equal ownership shares, and the unity of possession. You can't physically see which part of the property is yours versus someone else's. Now that we know all of this, we understand and recognize the differences between these forms of ownership. Don't ever explain someone what form of ownership they should take, because that is legal advice, and we are not attorneys, so we don't give legal advice. Okay? When it comes to business structures, we have different types of business structures. We're not talking about ownership of real estate right now. But wait a second. Can a business own real estate? Like not an individual, but the business itself own real estate?
Yes.
Yes, it will be a trust.
Yes, they can. But the thing is, if someone comes to you to list property for sale that's owned by an LLC or a corporation, what do you do? Do you just take the listing? And if you take the listing, how do you know that this person is authorized to sell the property? How do you know that they're related to that business? You're going to need some sort of a documentation, like a resolution passed by the board of directors in a corporation, or some sort of paperwork from the LLC that says that this is the authorized signatory who has the right to sell the real estate or purchase real estate on behalf of the corporation or LLC, right? Otherwise, it's like you not checking someone's ID before getting a listing or writing a contract to buy a property. You have to make sure who you're dealing with is authorized to sell this property for the corporation. Make sense? Okay. But a lot of people don't even think about that. You think a guy comes in, yeah, it's my company. I'm looking to sell the property. And then you just take their word for it. Don't do that. Just like checking their driver's license to ensure that a homeowner is selling their home, they are who they say they are. You want to make sure this person's the authorized, has the authority on behalf of that business to sell it. Okay. Well, let's talk about business structures for a second. What is a sole proprietorship? It's an ownership by one person of a business. A partnership is when you have two or more business owners. They're partners. Corporations are legally formed business entities that have big expenses and a lot of paperwork and a lot of people in different positions to manage a corporation. It's fairly complicated. Okay, they need to file paperwork on an annual basis. It's going to cost you a minimum of $800 a year to keep the corporation to renew the corporation's filings with the state. LLCs, well, there's expenses involved too, but they're a lot, and the paperwork is a lot more streamlined, and the costs are a lot less. Why do people form corporations or LLCs, which are limited liability companies? Well, it's for taxation purposes and for legal protections. Okay, like an LLC, you get taxed once through the company, and so it streamlines it. It makes it a lot easier. Corporations, the corporation gets taxed and then they pay you, then you get taxed, so it gets taxed multiple times. Now, if you form an LLC to run a business and you start making a lot of money, I think it's somewhere around 50 to 60,000 or more a year. that LLC should probably be registered as an S corp, file their taxes as an S corp. That's around the threshold where it starts making sense. But talk to your own um, tax attorney or CPA about this. I don't want to give anybody legal advice, and I don't want to give them tax advice either. So make sure when you're starting a business or anything like that that you do so with that proper advice. So, but LLCs can file taxes as S corps. Actually, I have some videos about this that I'm not going to show you at all right now, but I do have links to that I could share with you about. There's a really good tax guy. There's a couple of them out there, but there's this one guy. He's a really good tax guy. He tells you about how to register your company, how to file the taxes as an LLC. If you're creating an LLC, what to look out for. Um, Hold on, I've got those right over here somewhere. Okay, S corp. So the new LLCs, avoid mistakes in starting LLC, how to fund your LLC. Okay, there's a couple of them. Oh, and let's see, LLC benefits of starting an LLC. Okay, I got a bunch of these links I could share with you right now. How to pay yourself in an LLC. There, I'm going to share some of these links with you if you guys are interested in them at all. I don't know if you have maybe another business idea that you want to get involved in. Here's some good links right there. Okay, and so basically you're going to be seeing like benefits of LLC in the top write-offs, how to pay yourself as an LLC, how to avoid mistakes, how to file new LLCs as an S corp, how to fund your LLC. But it's basically this guy. I'll just show you him.
From paperwork to privacy, filing.
I'm not going to show you the video, but we'll just we don't have time for that. But I'll just show you. It's this guy.
You're
right
somebody
here.
that's new to business. Make sure you watch all the way till the end of this video because I'll give you insights on how you need to pay yourself.
He's pretty straightforward. This guy is smart as hell. He's great at he's some sort of a tax expert, and he gives really Carlton Dennis is his name. So he gives great tax advice to people, especially with businesses and such. So if you're not following him, he's actually a pretty good one to follow too. But here, I just sent you the links. You could go to his thing and decide if you want to follow him or not. All right. Let's move on from that. So syndicates and joint ventures, they're not legally formed business entities. But what are they? Well, a syndicate is a joining together of two or more people to carry out a business project. You don't have to file with the state paperwork and pay fees to create a syndicate. Okay, it's two or more people come together to do a business project. Maybe we're going to buy a property together, fix it up, flip it, and sell it. And then when we sell it, the syndicate's done. That partnership's done. Okay, a joint venture is similar to a syndicate. It's not a legally formed business entity, but instead of two or more people coming together for a business project, it's two or more groups or businesses that join together for a business project. And the project is done, the joint venture is done. And we're also going to learn about real estate investment trusts. We call them REITs. They get certain tax advantages like mutual fund investors do. For some reason, we need to know that for exams. The REIT investors get the same tax advantages as mutual fund investors. But who says you need to invest your retirement plans in mutual funds? Why not invest them in real estate through a REIT, a real estate investment trust? Okay. So we're going to go over that stuff in this chapter as well. So, you know what? Let me create a new slide here. I'm just going to post there some of those links that I just shared with you so that future classes can also have access to it. Let's get to it. Forms of ownership, types of business structures. Okay, and then I'll create this as a tax advice for LLC. Okay, so, and I'll just write in here that this slide is for your own education and should not be considered legal or tax advice. With your own tax. Okay, and then I'm going to put those links there, and we're going to put that as a list. Tax advice. For LLCs, okay. There we go. I just made a slide and I just put those links in a slide also, which I will upload into shared Google Drive so you'll have access to them as well. All right. This is what I did. So I created this slide, tax advice for LLCs, just to put that info in there for you that you'll have the access for it. The slide is for your own edification. It should not be considered legal or tax advice. Consult with your own tax attorney or CPA. Okay. Did you want to take a picture of that or something? There you go. Sorry. Just tell me if you do, because sometimes I move through these things. By the way, all these slides and these slideshows are available to you in the shared Google Drive that you could download. Okay. So if you wanted to grab them, you could.
Thank
You're welcome. All right. Business partnerships. Do these highlights. We already went over these, but what is the difference? There's different types of partnerships. All partnerships have at least one general partner. A general partner is someone who actively engages they're a business owner who actively engages in the day-to-day activities of the business, and they could be held liable for any additional debts that the business takes on. During this last rewrite, they had giving their 2 cents in making modifications to the book, and they wrote like all kinds of helpful tips to remember things and advice, and they changed these definitions and they made them wrong, completely wrong for partnerships. So I want you to cross out the sentence here where it says, ironically, there's no general partner in a general partnership. I want you to cross out that sentence. It's totally wrong. Okay. In a general partnership, all the co-owners are general partners. Every partnership has at least one general partner. In a general partnership, all the business owners are general partners that work the day-to-day activities of the business. And therefore, they can all be held liable for any additional debts that the business takes on. In a limited partnership, there's only one general part. Well, there's at least one general partner, but the others are considered limited partners. They're limited in their liability to the extent that they could only lose their initial investment in the business. They can't be required to put any more money out of pocket if the business takes on additional debts. They're not responsible for them. Okay? So let me give you an example. Say you want to start a business and you go to the bank of mom for a loan, right? Mom don't care about what your business. She just hopes you're successful in all your endeavors, right? So she doesn't know anything about your business. She just hopes you're successful. So she loans you the money to start your business. So now mom's a partner in your business. Like it or not, she's a partner. She's a limited partner, though. because she doesn't work in the business. She doesn't know anything about it. She just made a financial investment in your business there. So if you take out any additional loans, because you're the general partner, you're the one that's running the business. If you take out any additional loans because you need more money for the business, mom can't be responsible for paying back those loans. Creditors can't come after her because she just invested in your property. She's an owner, but she's a limited partner. She could only lose her initial investment if your business fails. She can't be held responsible for paying any additional debts that you take on. Okay, so that's basically the difference between a general partnership and a limited partnership. They both have general partners, but a general partnership, all the co-owners are general partners. In a limited partnership, there's at least one. And then the rest are limited in their liability. They're limited partners. So also cross out this explanation down at the bottom that they gave, because that's wrong too. So whoever made that last contribution to this book, wrong. Which, by the way, I need to submit all these changes because I'm submitting changes to the book manufacturer to correct this crap. I just didn't get around to doing it.
So this limited partner is equivalent to silent partner?
Yeah, it's basically what they are. They invested in your business, but they don't play a role in your business. So they're limited. Right? It's like if you invest in Google. Do you have a say in Google as a limited partner? No. All right. So here's the slide with all the wrong stuff taken out and the full explanation, like I explained it to you verbally as I've explained it. These are the definitions for general partnership and limited partnership that you should know. You will get some sort of a question about needing to know the difference between a general and limited partnership. Okay. Remember, I changed slides. If you needed to go back to snap a picture or you needed to copy notes, you need to tell me, go back, please, so that I can snap a picture or take a note or do a highlights. All right. Because I'm not going to sit here waiting and waiting and waiting. I need you guys to let me know. And if you don't, I just move to the next slide. If you need to take a picture, just say, hold on a sec. I'm going to take a picture or take some notes. Okay, I can see you are doing that right now. So because I can see it, I will hold off until you're done. There you go.
Thanks.
You're welcome. All right. Now, real estate ownership by corporations. Corporations are fictitious entities. They're artificial people for taxation purposes and legal protections. So corporations cannot own real estate as joint tenants or tenants by the entirety. Because a corporation's life is a perpetual existence. Until it's formally dissolved, corporations can live on forever. You know, if the president or CEO dies, they just replace that person with someone else and the corporation's life lives on, right? So corporation's life is a perpetual existence until it's formally dissolved. It would always be the last man standing, so to speak. And a corporation can't be a tenant by the entirety because corporations don't get married. People do. And when corporations join together, it's not called a marriage, it's called a merger. So corporations can only own real estate as tenants in severalty if it's a sole ownership, or tenancy in common if it is a partial ownership. Now, who makes all the major decisions in a corporation to buy or sell real estate? Well, those decisions are made by the board of directors. Now, if it does not involve a substantial amount of the real estate that the corporation owns, then the president or CEO can sell a property. But if it's a if it's going to be for a major amount of the property that they're selling, they need to get the approval of all the shareholders, okay, or a majority of the shareholders. But if it's only one or two properties, the CEO can run it by the board of directors, and the board of directors make those major decisions. Typically, that's how it works. Okay. So who makes all the major decisions when it comes to selling or buying real estate in a corporation?
Board of directors.
The board of directors. That is correct. So we're actually going to go to page 366 and highlight something there in just a moment after we highlight this on page 124. First on 124, let's highlight this. Corporation is a legal entity. Real estate ownership by a corporation is in severalty or in tenants in common if it's a partial ownership. And a corporation is managed and operated by its board of directors. Then I got a cross-reference here of page 366. Here they talk a little bit about an S corporation. You know, investors may opt for an alternative corporate ownership structure called an S corp. Like a corporation, this form of legal entity, but the investors avoid double taxation. Only the shares of profits passed to the shareholders are taxed, while the profits of the S corporation are not. However, S corporations are subject to strict requirements regulating their structure, membership, and operation. A lot of paperwork. Now, if we go to page 366, we would highlight this. A corporation can convey real estate only upon a proper resolution passed by its board of directors. If all or substantial portion of a corporation's real estate is being conveyed, well, they need to pass a resolution authorizing the sale after securing an approval from the majority of their shareholders. And deeds to real estate can only be signed by an authorized officer on behalf of that corporation. The authority of the officer has to be granted by a resolution properly passed by the board of directors, naming a particular person as the authorized signatory to sell that real estate on behalf of the corporation. Sometimes they may stamp it with a corporate seal. Sometimes they don't. So the corporate seal does not need to be affixed onto the conveyance unless there's an acknowledgement that mentions the seal. Okay. But all you need to know is what I highlighted here. Who makes all the major decisions to sell or buy property on behalf of a corporation?
BOD.
A proper resolution passed by its board of directors. All right. I already explained what a syndicate and a joint venture is, but here's a slide for it. It's a joining together of two or more people to carry out a business project. It's not a legally formed business entity. When the project is done, so is the syndicate. And a joint venture is the same thing, except instead of two or more people, it's two or more groups they come together to carry out a business project. It's not a legally formed business entity. When the project is done, the joint venture is done. A REIT is a real estate investment trust. It's a form of organization useful for taking advantage of certain tax benefits. They get the same tax benefits as mutual fund investors. In order to have a REIT, there must be at least 100 investors, and at least 75% of the trust's income must come from real estate as the investment vehicle. It is a stable investment that pays out slow and steady. An example of a real estate investment trust, they often purchase large apartment complexes with several hundred units or high-rise buildings and business centers and shopping centers. So it's fairly stable that they're going to be able to collect on rents, even though you get one tenant that may not, overall the business is profitable and collecting in on the rents, right? So it's a stable investment for you to invest in. It's a slow, steady payout, kind of like mutual funds. So it's a good investment if you want a stable investment for your retirement plans. Now, mutual funds usually don't pay out huge amounts unless that mutual fund decides to sell the entire apartment complex. And then when they calculate what the profits are on it, then you would get a huge amount. But they usually hold on to them. They're not looking to sell them. I've had REIT investors come into my office before asking if I knew of any apartment complexes with several hundred units or business complexes and things like that. They're like, yeah, we usually look for things, but we're usually, the smallest purchase we make is usually around $10 million or more. I was like, oh, I wish I had that kind of knowledge about somebody selling something that big, but these huge apartment complexes, I mean, these could be huge deals. This is a pretty good slide right here. It has everything you need to know about REITs, because otherwise we're going to highlight a little blurb about REITs, and then we're going to have to go to page 333 to highlight that they get the same tax benefits as mutual fund investors. Okay. So as you can see right here, this is on page 124. Real estate investment trust REITs is a form of organization that's useful for taking advantage of certain tax benefits. I wrote in here, same benefits as mutual fund investors, see page 333. And then on page 333, you could highlight real estate and trust investment trust REITs. Real estate investors can take advantage of the same tax benefits as mutual fund investors. And then it goes on to explain what the requirements are to have a REIT, but you don't need to know that for exam. You just need to know, who do REITs get the same tax benefits as? Mutual fund investors.
Got it.
Good. Let's talk about condominiums. You guys know what condos are? Condominiums? Heard of them before? What about co-ops? You ever hear of a co-op? Cooperatives? We're going to learn about condos, co-ops, and timeshares. Okay. So let's read through this together. Condos and co-op ownership of housing has risen in the second half of the 20th century, together with townhouses and planned unit developments that we call PUDs for short. Condos and co-ops offer emotional, financial, as well as tax advantages of home ownership, combined with the various advantages of apartment living. As opposed to traditional single-family homes, which can also be considered condos sometimes. Condos and co-ops offer more efficient use of ever scarcer building land, lower cost for lot development per living unit, and less outlay for construction per living unit, and some savings in maintenance and the heating bills. Contributing to the growth of condos and co-ops are changes in population patterns, with increasing number of single homeowners and one-parent families. Why is that stuff increasing? Single homeowners and one-parent families. Our societal changes. We've got less people believing in God. We've got people that are always criticizing what you hear on the news. They call it the nuclear family. You know what a nuclear family is? I had to look this up myself. Why do people refer to it as a nuclear family? It sounds like it's something evil. It's a bomb that's going to blow. A nuclear family is where you have a husband and a wife with the children, not just a single parent. Okay. That's actually a good thing.
It sounds like backwards. It sounds like that's a bad thing.
Doesn't it? Well,
Yeah.
who makes up these terminology? You know, so because of our societal changes out there, we have a lot of things that are changing in our society, and you could just see it out there. In the past, we go to war. We got the left, we got the right, but we stick together as Americans, and that's what makes us so strong. We can't be divided. When somebody attacks us, we get together and we pull together as a team, and we fight for our country because we love it. Okay, look what's going on right now. You got comedians on late night hosts that are wishing for the president to be assassinated and making jokes about it. What the hell is going on with these people? And then you got people all over social media laughing about it and yucking it up. This is what happens when you don't kick your kids out of the house to go play, and all they do is play violent video games all day. Look at the guy that just tried assassinating the president the other day. Very smart guy. They said he created video games. One of the video games he created? Tell me if this isn't sickening.
Was it Roblox?
Yeah. Yeah. Do you know what that is? It's a video game where somebody comes in to a school and tries to shoot down as many people as they can. And if you hover your mouse over the people that were killed, they actually highlight the name pops up of kids that were killed in those school attacks. I don't know how parents aren't suing them over that. That's sick.
They can't sue it because they be buying it for the kids. That's would be sick. Backwards.
Well, not parents. Them. Well, those parents aren't, because their kids were killed.
Oh God. No, I'm talking about
the
parents of the kids that play the games.
Yeah, it's a pretty sick world we're living in right now. It's twisted, less patriotism. People, oh yeah, America is not a great place to live, right? Well, then go someplace else that you think is. I can't stand hearing that. I think we all should pull together, the left and the right. We can't even sit down and have a conversation about funding our national security, and come to an agreement on that, because everything's got to be partisan. It's got to be my way or the highway. Whatever happened to negotiations and doing what's best for the country? No, we do what's best for political parties these days. That's why it's so hard to get things done. But this is some of the stuff that contributes to single homeowners, one-parent families, and senior citizens. There's relationships have changed. People are telling you that you don't need to get married. You're better off staying single. Don't have kids because global warming is going to kill them anyway. All this idiocy, but people listen to it. And they actually adjust their lives by it. And it does change society as a whole. So you need to be a people watcher if you're going to be in real estate. You need to watch what's going on in the political climate as well, because things play a role on real estate eventually. So to such groups, community living offers security and sociability, ease of maintenance, and sometimes the opportunity of sharing expensive recreational facilities like Olympic-sized swimming pools and exercise rooms and IMAX movie theaters, even tennis courts, basketball courts, all kinds of things like this are available in condominium and cooperative complexes, which you're not going to be able to put an Olympic-sized swimming pool, rec rooms, and all these things if you have a single family house, right? That's going to be very expensive. You need to have a big property for that too. So the terms condo and cooperative refer to the forms of ownership. And looking at a shared housing complex gives you no clue as to what form of ownership it is. It could be a condo, a co-op, or in some cases, a planned unit development, a PUD. The buildings themselves can be any architectural style. They could be high-rises, townhouses, patio homes, garden apartments, or even single detached homes can be within condominium complexes and part of a condo. The differences arise from the legal form of ownership. Condominium ownership's not limited to residential dwellings either. There's commercial condos out there. You guys ever go to a doctor, a dentist, an attorney, a tax preparer, a masseuse, or somebody or a real estate agent who has an office in a condominium, a business condo. They're out there. Cooperative ownership now was common in New York City, still is. It's also found in certain areas of New Jersey. Cooperative ownership became popular in the 1920s as the urban population grew after World War I. Individual housing became more expensive, and the boards of directors were choosy about who could buy in. Oh, choosy of who could buy in. Makes it sound like they're doing some discrimination, don't they? Well, that's not what they're doing. I mean, could there have been discrimination ever? Yes, but that's not the objective of boards of directors being choosy of who they allow to buy into co-op complexes. The reason that they do that and have an application or an interview process is because they're looking out for all of the residents as a whole in the complex. The number of newly built cooperatives have decreased greatly over the last 50 years. Under the usual cooperative arrangement, highlight title to the land and building is held by the corporation, and each purchaser of an apartment in the building receives stock in the corporation and a proprietary lease. So when you own a co-op, do you own real estate?
Yes, partially.
No.
No, got it.
You own stock in a corporation that owns the real estate.
Got it.
You become a shareholder in the corporation that owns the real estate, and in exchange, they give you what they call a proprietary lease. That's a fancy name for a custom lease that gives you the right to occupy the unit that you're living in. Okay?
Okay.
So, actually, this whole sentence should be highlighted, which gives the purchaser the right to occupy his or her apartment. Actually, you should highlight that whole line right there.
Okay.
Let me find it, and I'm going to highlight it too. Where the hell are we? Oh, there we go. Draw, highlights. Oh, not there yet. What slide is that? Oh, there we go. Which gives the purchaser the right to occupy the product. There we go. Doo-be-doo. Doo-be-doo. All right. Now, co-op owners don't actually own the real estate. They own stock, which is personal property. So can you get a mortgage loan to buy a co-op? Think about it for a second. What is a mortgage loan? What is a mortgage? It's a promise to pay. In exchange, the lender gives you a loan. But what is the promise that you're making to the lender? I promise to pay you back according to the terms in the note, and if I fail to, you can foreclose on me, sell the property at auction to pay off the debt. Ah, but you don't own property. You own stock in a corporation that owns the property. So you cannot get a typical mortgage loan to buy a co-op. You need to buy cash or personal loan. Now, each prospective owner must be approved by the board of directors. And co-ops usually have a minimum credit score requirement to purchase. They usually have a minimum 620 credit score requirement. Anything below 620 is considered prime. That means average. Anything below 620 is below average. So they have this requirement, unlike condominium buyers. You know, if you could afford to buy a condo, you're in. You don't need to be approved by any board. Co-op owners, they do an application process. They may even have an interview process. They have a minimum credit score requirement. Why do they have all of these things? Well, we'll see coming up why. So right here, we'll tell you. One disadvantage of cooperative ownership is the possibility that if enough of the owner occupants become financially unable to make their monthly assessment payments, the corporation may be forced to allow their mortgage and tax payments to go unpaid. Because the corporation makes their mortgage payments on the whole entire property and the tax payments, and they maintain all of those recreational facilities, the pool, the landscaping, all that stuff, the snow removal, the garbage removal. It all comes out of your monthly payment, right? Condos have them too, but they're usually much smaller because co-op monthly payments for the common area elements, or we call them CAM payments, are usually larger because they include the property taxes, insurance, and such that the corporation pays on the property. So if enough people don't make those payments and they go unpaid, it could cause the entire complex to get foreclosed on. So even your neighbors that are paying their monthly assessments could get foreclosed. So this is why they have that interview process and the minimum credit score requirements and such. They're trying to look out for the community as a whole from unstable people who don't have a good history of paying their bills. All right. Now, one benefit of buying a co-op is they're usually a lot cheaper than buying a condo. Because with a condo, you own the real estate. With a co-op, you don't. But anybody that visits you isn't going to know. Your kids aren't going to know the difference. Why? Because you have a place to live, right? Once you pay it off, all you pay is the monthly fee and maybe a renter's insurance for your personal belongings. All right, so highlights, such a sale might destroy the interest of all the owners. Accumulation of substantial funds of reserves for future repairs and emergency payments. So what are reserves? There's your definition right there. Reserves are an accumulation of substantial funds for future repairs and emergency payments. Let's say that this winter we get a lot more snow than we normally get. Or let's say that there's a lawsuit and we have an emergency payment for attorneys, or a tree falls on one of the buildings or whatever. We need to get new roofs or whatever it is. The shareholders have all the same income and tax advantages as the owner of a single family home, just like a single family homeowner. Many co-ops do not allow rentals because if you have too high of a rental, too many renters there, future buyers may have trouble obtaining financing to purchase in. And the reason being is who takes better care of their property? Renters or owners?
Owners.
Yeah, you're right. They do. And the lenders know this too. So if somebody's going to give you a personal loan to buy a co-op, they want to make sure it's not going to drop in value because they got too many renters there that are destroying the place and not taking care of it. This is why generally most co-ops do not allow rentals, except in some circumstances. And because of that, we're going to highlight here, most co-ops do not permit rentals. And then we're going to highlight, there is a New Jersey law, however, that says that if you're a owner of a co-op in a building, in a co-op complex with 10 or more units, and you've been trying to sell your unit for 4 or more months at a price no greater than what you purchased it for, you could rent it out if you're unable to sell it in that circumstance. Because most co-ops have in their rules, you're not allowed to rent out your unit. Are there co-ops out there that allow you rentals? Yes. They may have certain restrictions on it, like you need to have lived there for at least 2 or 3 or 4 years first, All right, let's move on. So title to the land is held by the corporation as the owner. So purchasers do not own real estate. They own stock, which is an intangible personal asset. The proprietary lease is a fancy name for a custom lease, which gives the tenant stock owner the right to occupy the unit they're living in. Income tax advantages are identical to those of single-family homeowners. The tenant has a voice to control the property management through their stock ownership. Maintenance fees are usually much higher than they are with condos because it includes the mortgage, tax, insurance, and the CAM payments for maintaining the common area elements. Often, the sewer bill, water, heat, trash, and snow removal are included. The value of the property tends to be a lot more stable and doesn't fluctuate as radically as condo ownership may. There's a shared expense usually for one underlying mortgage on the entire property. They have tenant shareholders. Taxes are charged to the corporation as the owner and billed to the tenants as part of their monthly maintenance fee. There's something called bylaws, which require each purchaser must be approved by the board of directors and who manages the corporation. Usually there's a minimum FICO credit score requirement of 620. Most co-ops do not permit renting because if there's too many renters, people may have trouble obtaining financing to purchase units, except for that one exception there in complexes with 10 or more units where you've been trying to sell your unit for 4 or more months for a price no greater than what you bought it for, then you're allowed to rent it. That's a New Jersey law, despite what they may have in their rules. Long-term stability of tenants is common, and you finance the purchase with a cash or a personal loan, not a mortgage loan, because you don't own the real estate, so you can't pledge the property as security for the loan. Now, real estate agents, we cannot prepare sales contracts for co-ops. We could put them in the MLS and we could market them for sale. But the actual writing of the contract, we prepare them for condominiums, but we cannot prepare them for co-ops because co-ops, we're selling stock and we're not licensed to do that. So the contracts must be prepared by attorneys because we're selling stock, not real estate. All right, the first condominiums. Now let's talk a little bit about condominiums. The first condominiums were built in Puerto Rico in 1958, and the FHA was allowed to insure mortgages for condominiums by 1969. And many people were introduced to condominium ownership in Florida, where it became very popular. It was introduced, the concept, from Puerto Rico. Popularity stems from the ability to obtain affordable housing, often in highly desirable areas that's typically beyond most people's economic reach, right? Can most people afford to buy a house in some of these expensive areas within Florida where it may be a lot cheaper and affordable to buy a condo instead of an actual land with the house on it? It's a lot more affordable to buy a condo than it is the single family detached house. So let's highlight there that buyers of a condominium receive a deed conveying fee simple ownership of two things. Everything from the paint on your interior walls inward, because you can't break what's behind the walls. Those plumbing is common plumbing that all the units are sharing. So you can't mess with that. You need to contact the management if you want to mess with the plumbing behind the walls or tie into it. And a proportionate, undivided interest in the common area elements. Common elements could be like the exteriors of the building, hallways, basements, elevators, driveways, stairwells, private roads, sidewalks, lawns, landscaping, and all the recreational facilities that could be there, like the swimming pool, tennis courts, basketball courts, IMAX movie theaters, ballrooms, which you could reserve, or meeting rooms or what have you. In many respects, condominium ownership is regarded in the same light as the owner of a single detached house. How so? Well, title could be held in severalty or by the entirety as joint tenants or tenants in common. The unit receives an individual tax bill and may be mortgaged as a house would be. The owners place a separate insurance policy on their living space, and the income tax advantages are identical to those as single-family homes. The owners are free to sell the property, lease it, or give it away, or leave it to their heirs. And each unit is a financial entity. And if your adjoining unit of your neighbor gets foreclosed, it does not affect your property. It does not affect your unit like it would with a co-op. If enough people don't pay the bills, the entire complex can get foreclosed. You could have one unit in a condo gets foreclosed, but the next door neighbors doesn't affect. Now, owners are, however, bound by the bylaws of the homeowners association, to which all will belong. If you're an owner of a condo, you're a member of the homeowners association. Now, as long as the rules are not unreasonable, New Jersey law permits associations to enforce their rules by fining residents who fail to comply. Okay. Now, if you buy a condo, everybody who owns a condo unit is going to be a member of the homeowners association. But do you buy a condo to get involved in mini government to manage a complex, or you just because it's an affordable place to live? Probably the latter, right? But there are people who volunteer to be on the board of the condo association to sit there and have meetings and debate rules and things that should be passed. And every unit owner has the ability to attend these meetings, which most do not. But then they're later pissed off because they find out that all of these rules were passed that are very restrictive on the homeowners. They could say, you're not allowed to have a washer or dryer in your unit. You know, no oversized or commercial vehicles can be parked in the parking lot. No decorations in the flower pots. So you're not allowed to have like a little American flag even, because if you do, then somebody else is going to be posting a ISIS flag or a trans flag or a whatever, and somebody's going to get offended, you know? So they say no decorations. They call them decorations in the flower pots. Okay. They could restrict you from painting your front door a different color. Okay. Why? Because if people start doing this and it starts making the community look really weird, you know, different colored doors and everything, different kinds of people planting plants and flowers, it doesn't look uniform. And with uniformity, it maintains value better for the long run. Okay. So that's why they don't want you painting your front door a bright orange, or they may even restrict you from being able to put a for sale sign on in front of your unit or even in your front window. These could be restrictions. So how would you hold an open house in a condo? By appointment. That's how. So
who is above a homeowners association, who they are answerable to, and who are, if every member of condo is the member of the homeowners association, then who are making these laws? I mean, are there also elections?
Laws, they're rules. And yes, they have elections for the board members. Because you didn't want to be a part of it, because, hey, you moved there just to have a place to live and you want them just to manage the place properly and keep it nice, right? You don't want to be involved in the politics of it, right? So everybody that lives there, that's part of the homeowners association, will vote and elect somebody who volunteers to be the president, the treasurer, the whatever, you know. So basically they have all these positions, just like if you had a single family house and you lived in town, who does the same stuff? The city council and the mayor.
Mm-hmm.
It's like a mini government within your own complex. Okay. And that's the way that it works. So let me ask you a question. Do politicians in your town ever get corrupt or mismanage funds because it's other people's money?
Yes.
Absolutely.
Yeah. I want you to answer. I know the answer. I want your opinion on it, right? Of course. You know, so you got to keep an eye on these people and get them out if they get a little crazy. Homeowners, listen, I sold a lot of condos in my time. And most people were very happy about the complexes that they lived in. And the number one reason why they probably moved out, other than their family was growing, or they needed to move for their job or something like that, the number one reason was because the people on the board of the homeowners association ran the place like a bunch of Nazis. They walked around with their clipboards and they're like, oh, this is a violation of the rule. Here's your first warning, 3 warnings and you're going to get fined. Like people are all up in your business, they got nothing better to do. So they take their duties seriously, get the hell out of here. This is a place for me to live. You're not breaking down your cardboards, stuff like that. I'm actually going to show you a goof video that was a commercial that Geico made that goofs on homeowners associations. Listen, a lot of stereotypes become stereotypes because there's some truth to them at some level. And you're going to see this in this Geico commercial showing you the stereotypes about homeowners associations. All right. So
okay.
Yeah. You had a question? No? Okay. So let's see. The New Jersey law permits associations to enforce their rules by fining residents who fail to comply. However, while condominium boards can stall or exercise a first right of refusal, they rarely have the right to evict an owner if they're not paying their monthly fees. Those monthly fees for the maintenance, insurance, and management of the common elements, they could lead to foreclosure, but usually if they're not getting paid, neither is the mortgage loan. And the lender will probably foreclose on them first. I have seen, but it's not very common, the homeowners association foreclose on condo unit owners that aren't paying their monthly association fee so that they could then kick them out and then rent it to someone else to get as much of those those monthly fees back. They could recoup them. And eventually they know the mortgage company is going to foreclose on them because they're not making mortgage payments. So if unpaid, these common charges become a lien against the individual unit and can be enforced by foreclosure. Now, the bylaws also set up something called CC&Rs. That stands for Covenants, Conditions, and Restrictions. These are the rules that the association puts in place that could restrict you from painting your door orange or putting up a for sale sign, etc. Okay. So condos are governed by their board of directors, consisting of often elected volunteers who actively live in the building. And I've seen this before. These are like elected politicians. Because I've helped so many people sell and buy condos, I've learned what attorneys look for. Usually, if you're purchasing a condominium, you really need to get a copy of the bylaws, and you need to get a copy of the financials for the last 2 to 3 years. I've asked attorneys, what are you looking for in the financials when somebody's buying a condominium? And they told me, well, we're looking to make sure that there's no ongoing lawsuits against the complex. Otherwise, I'm going to suggest that you don't buy it until it's settled, because that could cost everybody their money. And you want to look and make sure that the overall monthly cost to run the complex and maintain the complex, that the association has in their reserve account enough money to run that complex for 3 to 4 months if another penny did not come in. If they don't have a minimum of 3 to 4 months of operating expenses in the reserve account, it's being mismanaged. And the monthly association fee is going to be raised soon. Okay, so I'm passing on that knowledge to you guys right now. And what about the bylaws? Well, we just want to make sure there's nothing too crazy in there and make sure that the rule book maybe is this thick and not this thick. Because then they're crazy. They're running the place like a bunch of Nazis with all the rules they put in place. Okay. Now, those members of the board of directors act as fiduciaries. They're responsible. They have the responsibilities of loyalty, care, and duty to protect the community. They should have enough time to be involved and possess the knowledge, just like any politician would, to manage a municipality as they would to manage the complex. And the day-to-day operations of condominiums are generally handled by a condominium manager. In New Jersey, the creation of condominiums is regulated by the state's Horizontal Properties Act and the Condominium Act. Okay, so in New Jersey, the Condominium Act applies to condominium associations created after January 7th, 1970. So what's required to create a condominium? First, the owners of the property execute and record a master deed, and they file it in the public records in the county where the property is located. And many items have to be contained in or attached to the master deed, including a legal description of the land, as well as drawings, the graphic descriptions of the buildings and other improvements, which identifies the individual units by letter, name, or number, and specifies a percentage of the common elements, if any, are to be included in the ownership of each individual unit. A description of the common elements and a provision for association of unit owners and a starting out list of bylaws for that association. All right, so that's how you create a condominium. If you buy an apartment building or a multifamily house, do you know that you could turn that into a condo as well? We're going to go over, that's called a condominium conversion. And we're going to go over what the requirements of that are after you see this. We already read about this. I just have this all as notes on a page here for you. When you buy a condo, what are you buying? You receive fee simple ownership of two things: your living unit and everything from the paint on the interior walls inward, and a proportionate undivided interest in the common area elements. You're going to be a member of the HOA, and that's the Homeowners Association. There are bylaws that set up covenants, conditions, and restrictions to which these are the rules which everybody needs to follow. There's an HOA fee that everybody needs to pay monthly. That's your monthly CAM. CAM is a common area maintenance charge that pays for the landscaping, the trash removal, the sewage, the water, all that stuff. And condominiums are usually managed by a board of directors from the are usually managed by the Homeowners Association, but they usually hire professional managers, property managers, if there's 25 units or more. But that's not always the case. Here's that goof video I told you about that what do you call it? Geico made. Now take a look at the building behind this. These people, this is a condo complex. But remember, condominiums can be any architectural style. Most people think of condos, they picture apartment style living. These are single detached houses, or maybe it's two units attached to each other. Let's take a look. Jack up the volume here a bit. All right.
Oh, we love our new home. Neighborhood's great.
Amazing school district. The HOA has been very involved. These shrubs aren't board approved. You need to break down your cardboard.
Thank you.
Violation. Violation.
I see you've met Sid. Yep.
At least Geico makes bundling our home and car insurance easy.
It does help us save a bunch of money.
2 inches over regulation.
Thanks, Cynthia. For bundling made easy, go to geico.com. Oh, we love our new home.
Yeah, it's so ridiculous. You got to goof on it. But these are some real things. Look, I give you some more real examples right here from the Realtors website. There's a HOA. Here's an article about a homeowners association that forces all of the homeowners to keep their garage door open during the day between certain hours. Could you imagine? Now, why do they do that? Because they found that some people finished off their garage and they're renting the garage or allowing people to live in it. So what business is that of yours? But most people store all kinds of stuff in their garages. Here's another one where a homeowners association forced all of the unit owners to purchase a $500 mailbox so that they all look the same. And there was one guy in this case who was actually a NASA engineer or something. And he fought this because he just purchased and made a beautiful mailbox, a custom cedar shake mailbox that he put at the end of his driveway to his house in the condominium gated community. So he fought it. And several years later, and about $30,000 in legal fees, he won. That the association can't force him to buy a $500 mailbox. Cost him $30,000 to win that case, though. But hey, he said he did it on principle. He's like, what's to stop them if I replace my roof, that they come in and they say, well, you need to change your roof because we need it to be a different color. It sounds ridiculous, but look at this. Cynthia's cutting down, their plants hanging from the tree because they're violation. You don't have permission. Or then Cynthia pulls out a chainsaw and cuts down your mailbox because it's 2 inches higher than regulations allow.
We love her.
All right. Where are we time-wise here? Oh, shoot, we're over time already. Let me see how many slides we have left here. See if we should finish this or just continue it tomorrow. No, we got some slides. So we'll just finish tomorrow. We're past time already. So we'll leave off here. Which slide is this? At the Geico slide number. Okay, the next one we'll start off on. Slide 43. We'll pick up tomorrow. Let me throw out here let me stop the recording first.